against ODM and Jubilee. So that the next question, my Lord, why were the agents of ODM and Jubilee signing the form?
All right, just the proceedings yesterday before that particular court hearing ended. Really, some of the final submissions that were there after the report was filed by the Registrar of the Court on the access of the IEBC servers, as well as the verification of Form 34As and Bs. And today is the first day the judges have retreated to just deliberate on the decision they will make. The deadline is Friday, as stipulated in the Constitution, 14 days after a petition has been filed. And joining me in studio now is Duncan Okatch, who is a lawyer. As you just take a look at some of the things we expect and do a quick post-mortem of how this particular process has been since it began. How do you assess this from when this particular petition was filed?
Akisa, to me, from a lawyer's mind and a lawyer's eye, and I believe even as a common ordinary citizen, it is beyond doubt that this particular Supreme Court from the onset has actually given an impression that it is not business as usual. It has actually indicated that it will do its business based on the law and it will not be bound by anything, including precedents set in by its predecessor court in 2013. And you can only take a look at the change in the addressing, and it informs a lot. There's a lot of significance and symbolism in that change of dressing. There would have been no reason at all to depart from the dressing that was introduced by the previous court and attributable to the Chief Justice then, Chief Justice Mutunga, as it then was. And they've actually come out with new dressing. No one expected that, but if you look at it, it actually almost conforms to the ordinary dressing that the judges use in the ordinary course of business. And there's even that directive that has come from the Chief Justice that all these other judges should be robbed when they are doing their when they are carrying out their mandate. Therefore, all in all, once you look at it, the first step was a right step in terms of the symbolism. But deep into the matter, you actually find that the decision that the court made, actually the direction that the Chief Justice was giving, when these parties tried to rely upon technicalities to knock out affidavits of the other, and they were actually carrying or basing the argument mostly from the decision of the 2013 court, whereby it knocked off the supplementary affidavit by Raila Odinga then, and say that he filed them out of time without leave of court and all that. Therefore, it was knocked out on a technicality. However, critics have actually said that that was an affront to the Constitution, and they actually indicated that Article 159(2)(d) was very clear and in uncertain terms. It actually stated that justice will be dispensed by the courts and the judges without undue regard to technicality. That means you look at the substantive justice. And if you look at the direction, he actually tried to talk to them, just agree so that we proceed. They couldn't agree. But when they retreated, the decisions that they made in as far as that particular matter is concerned actually breathed a fresh air to Article 159(2)(d), and actually in a very major way, and lawyers will tell you, has changed the jurisprudence as set out by the Supreme Court as far as Article 159(2)(d) is concerned. But more importantly, it also coincided with the 7th promulgation birthday for the Constitution, so that it was also symbiotic, that there's something new. It was actually a capping on the Constitution itself, saying that now the Constitution being progressive, and with this interpretation, we will actually look at justice, and nothing will impede justice, especially issues of technicality.
Looking at how the arguments were brought forth by the legal teams for the petitioner, as well as all the respondents and the friends of the court, as well as the interested parties, what are some of the things that stood out for you as a lawyer in this particular case?
Akisa, I'll endeavor to answer that, but you will notice that I'm also bound by this
sub judice, yes.
So I may not go deeply into the merits, but just in terms of what stood out is that you'll notice that in the petition itself, they brought out allegations of anomalies they actually tried, especially when Otinda Amolo was actually submitting, he actually brought out and went deeply into specifics in terms of the anomalies. And if you look generally in terms of what NASA was arguing, they are arguing, they made their submissions in terms of looking at the quantitative aspects of the law, which is captured in Article 86 of our Constitution, saying that it is not about the numbers alone. It is also about the process. So that if the process is flawed, they are saying that the result cannot stand. The result will also be flawed.
Yes.
But if you look at what Paul Mwangi also tried to say, he was actually saying even if these particular results, even if people demean and say that they were not so much, which was the argument from the other side, they were trying to indicate that on this other side, the results will be unverifiable according to them. But if you look at the IBC side on their end, they actually said, yes, there may be some issues here and there, but they were actually pegging the argument on the 2013 jurisprudence, which actually indicated and interpreted the Elections Act, Section 83, saying that where there may be some anomalies, but the anomalies actually do not lead to a difference in terms of the numbers, then those anomalies cannot be used to nullify a presidential election. So that majorly you look at them, they actually argued basically in terms of strengthening that particular position. Bring in the third respondent, that is the president, and you'll notice that his lawyers took almost the same position as the IBC lawyers, but more importantly, they actually tried to argue that as far as they are concerned, the numbers that they got, regardless of these anomalies, are verifiable, and they actually argue that it's not an issue of the transmission alone. They were actually arguing that these results are verifiable because substantially the elections were manual. It is only the transmission part of it and the identification part of it, and that was just a safeguard. However, the ballot itself that was cast is manual, and that ballot should be verifiable. If there's any dispute in terms of the numbers that were transmitted by the system, their argument was that you can just reverse and go to the ballot papers. And if you're going to the ballot papers, it means you just have to count them and look at Form 34A. Then you look at Form 34A, you look at Form 34B, which is actually a transcript and accumulation of the figures in Form 34A by the returning officer. So that the forms, the figures in the forms, if they still tally, and if there's an issue in terms of what was transmitted, they are saying the forms are there, the forms have been provided by law, as provided by law within 2 days, and they're saying, therefore, the elections will still be verifiable, so that any issue with the system, which does not actually affect the manual verifiability, should not be given credence.
What are some of the things, I don't know if you will be able to answer this, because of course you are, because of sub judice, you're not expected to say a lot on some of these proceedings, but what are some of the things that might inform, looking at the history of election petitions and not just presidential, what are some of the things that inform or play a big role in informing the decision that is taken by a bench?
That is a question that I can comfortably answer even without breaking that particular rule, because the law is the law. And that's why we have indicated there are two instances, and we look at our Elections Act and we look at the Constitution. Elections are actually framed pursuant to it's a constitutional process, and it is buttressed by the Elections Act and regulations, so that the main issue will be the burden of proof. What is the burden of proof? And generally in election matters, the burden of proof, we always say that it is a burden of proof that is below a reasonable doubt standard, which is the reasonable doubt is in criminal matters. You must prove your case beyond reasonable doubt. But you cannot say that an election petition must be proved on a beyond reasonable doubt. There's the other burden of proof, which is lower, which is called a balance of probabilities, which is in civil matters. But again, you cannot say election petitions should be proved on a balance of probabilities because it's a bit lower. Therefore, there's a place in between which lawyers, I always say, have not yet given it a name. They should baptize it. So we always say it's in between reasonable doubt and a balance of probability. It's like the gray area. It's a gray area. That's why it's a gray area that now it gives judges latitudes. But again, that is a bit too technical also for anyone, any viewer who does not have a legal mind or legal training. Therefore, I break it down further, and we have Section 83 of the Elections Act, which actually comes in and tells us that you must demonstrate that the elections were not conducted substantially in accordance to the laid down procedures, that is the law and the regulations. But on the other hand, and that is where the dispute comes in. Okay. The 2013 said you do not only demonstrate that there were irregularities, elections were not conducted, you must demonstrate that this particular non-compliance, you must relate it directly on the other end and say that it actually affected my votes in this way. And
those are the things judges will be looking out for.
Yes, but you see, the question will be, and if you had NASA arguing, and that is where, that's a new jurisprudence, they are saying, our law says or. So they are saying you can demonstrate